Hello everyone, my name is Habiba Wakari and this is Samira's Haven. In this video, we're talking about existing laws in Ghana. Article 11 Clause 4 of the 1992 Constitution states that the existing laws of Ghana comprises the written and unwritten laws as they exist before the coming into force of the Constitution, and any act, law, decree, or statutory instruments that were made before that but takes effect on or after the coming into force of the Constitution. A case where existing law was discussed was the case of Ellis and Another versus the Attorney General. In this case, the plaintiff's land was compulsorily acquired by the state through the Herman Land Acquisition and Compensation Law 1992, PNDC Law 294. This law took effect on the 20th of November 1992, before the coming into force of the Constitution on the 7th of January 1993. On the coming into force of the Constitution, the plaintiff brought an action to the Supreme Court for a declaration that PNDC Law 294 was inconsistent with the Constitution because they were not adequately compensated. They also argued that though PNDC law was an existing law in Ghana, it remains a valid law until it is challenged by a superior law like the 1992 Constitution. PNDC law was a valid law before the coming into force of the Constitution. And since the 1992 Constitution was a prospective law, PNDC law could not be set aside by the 1992 Constitution. The court stated that the PNDC law 294 belonged to a class of laws that pre-existed the 1992 Constitution. Therefore, PNDC Law 294 was an existing law. The land was vested in the states before the coming into force of the Constitution, and the compensation provided to the plaintiff was adequate. Therefore, PNDC law remains an existing law that is valid, as it will not be proven that it was inconsistent with the Constitution. Another case in point is the case of the Republic versus Abiola, Ayoride, Kayode, and Ananda. In this case, a Nigerian criminal syndicate had committed financial fraud against several financial institutions in the United States of America. In a bid to extradite the criminals that were resident in Ghana, the USA sought to rely on a 1931 treaty between the USA and the UK to do so. And the district court, the counsel for the accused argued that the 1931 treaty between the UK and the USA was not an applicable law in modern day Ghana. In the view of the district court judge, the case raised an issue of interpretation. Therefore, the case was forwarded to the Supreme Court for its interpretation. And the Supreme Court stated that the case did not raise an issue of interpretation because it was clearly stated in the 1931 treaty that it was to be applicable to all former colonies of the United Kingdom. Since Ghana was a former colony of the United Kingdom, the 1931 treaty between the UK and the USA was also applicable to Ghana. Therefore, that treaty was an existing law in Ghana. All laws in Ghana are subject to the supremacy of the Constitution, and existing laws are no exception. In the case of Mensima versus Attorney General, the plaintiff was a member of a registered cooperative union that distills a local gin called Apetition. He broke free from this union and registered a company where he continued to do so. However, members and officers of the union continued to harass him and impounded his goods. They did this in reliance on Regulation 31 and 37 of the Manufacture and Sale of Spirits Regulation 1962. That law stated that for a person to be given a license to distill the local gin Apetition, he or she must belong to a registered cooperative union. The plaintiff brought an action to the Supreme Court for a declaration that said law was inconsistent with the Constitution. The counsel for the defendant argued that the regulation was an existing law that had not been repealed. Therefore, the court must give effect to it. The court disagreed with the view of the counsel for the defendant and stated that the fact that an existing law had not been repealed does not mean the court has to give effect to it always. And based on the facts of that case, it was held that that existing law was inconsistent with the Constitution because it sought to force an individual to join an association he or she clearly does not want to be part of. In conclusion, the existing laws are the written and unwritten laws as they existed before the coming into force of the Constitution, and any act, law, decree, or statutory instruments that were made before that but takes effect on or after the coming into force of the Constitution. Also, the fact that an existing law has not been repealed does not mean the court must give effect to it always. I hope you learned something today. If you found value in this video, please like, comment, share and subscribe. Until next time, have a lovely day.